Main Bay of Elodium Morris Pradium, Ante, Colorado. Today is Class 49, Class 49. What did we learn in Class 48? Well, we started learning a little bit more about what's called France versus the United States of America of 1952, right? This is a case that came out of the International Court of Justice. And keep in mind that all cases that come out of the International Court of Justice are final. There is no appeal. So both parties accept that adjudication, that final decision of what the ICJ refers to as being authoritative decision of the ICJ. All right, so it's final. So while we're reading France versus the United States of America, remember that when we start to enforce our own treaty rights as being Moors, then we are utilizing some of the language that we're learning from this France versus the United States of America. So we're learning actually how to enforce our own treaties. So what should Moors start taking away from this? That the ICJ has already given us a lot of answers to the test. That the United States already knows some of the powers that the Moors already have in terms of how to enforce said treaties, right? But at the same time, what else is the ICJ doing? Pointing out some of the flaws and the mistakes and the misconceptions that the Moors have had in terms of how we enforce said treaties. And more specifically, the ICJ has pointed out that the Moors have acquiesced to our own sovereign rights. What does that mean? Well, we looked up the definition of acquiesce, and it means what? We've been passive. Passive at what? Not enacting legislation. What legislation? What is the first legislation that Moors had an obligation to come back to? We have to return to what? A Moroccan government. But what type of government? A Moroccan state government. So since the colonists ran us out of our Moroccan seats, our Moroccan governments, that way now we have to do what? Now we have to do what? We have to restore the states. That's the law of restoration, right? So we have to understand that through this pen, we have to return to Morocco with this pen and enact the first legislation, which is what? Constitutions. That is the first enactment of legislation that the Moors had to do. This is the reason why Noble Drew Ali tried to enact a constitution. And after that, Noble Drew Ali tried to enforce that constitution to get Moors to come into the sovereignty of understanding constitution principles. All right? So we're going to continue with the class. We're still on France versus the United States of America. We're going to keep reading several paragraphs of it. Then eventually we're going to go right into the Acta Algeciras of 1906. That way I can start explaining those 123 articles. Think about it, Moors. If the Acta Algeciras is 123 articles, and the average treaty is about 25 articles, right? Our Treaty of Peace and Friendship is 25 articles. That means the Acta Algeciras is almost like 5 treaties combined in one. So we'll go with that in the near future, okay? So let's get back to our class. As AMPAC has always talked about, we'll open up with our Constitution. Everything's about Constitution principles. We have to understand that our Constitution is all the Moors in each of the territories, right? When I say each of the territories, what does that mean? Okay, let's take a look at it. These are each of the territories. Each of these territories right now are under what you call conquest. Each of these territories, these borders, are now under what they call capitulation regime or regime of capitulation, right? So each Moor has an obligation to come back and return to Morocco through statehood of each of these territories to enact a constitution in each of the territories, okay? So Moors have to do that. We have no choice, all right? Okay, so AMPAC's constitution is all about our latitude, longitude of our jurisdiction. Our jurisdiction does not encompass the entire empire of Morocco because all states must have a fixed territory. You must proclaim your latitude, longitude of said state. So all Moors have an obligation to do that, okay? We must all do what? We must all do what? Restore. Restore what? The law. What law? The law of our constitutions. That is a part of the triple principle. The first step in the triple principle is what? sovereignty and independence of what? The law. And what law? The law of your state. Then you get into what? Integrity of domain. What domain? The domain of the latitude, longitude of your state. Then you can get into economic liberty without any inequality, etc., 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 as it relates to your state. All right? So everything right now is about restoring what? Law. What law? Law of the state. And then the seal becomes the thumbprint for all the nationals of that state. It represents the person. The person becomes this one person that represents the interest of all the nationals of said state. That is the seal. That is the thumbprint. Okay? That's what you put on all your documents. It represents the political interest of all the nationals of your state. Okay? All right, that must be understood. Okay, let's get back to the class. Okay, we're reading France versus United States of America. We were on page 200, okay? So we'll scroll down. We'll start right in the last paragraph that we left off on. It was kind of a lengthy paragraph, but we're going to start here as an overlap, all right? Okay, Mother, if you can go ahead and start, please.
During this period, France and the United States were in negotiation with regard to a number of questions, including the renunciation of capitulatory rights. There are isolated expressions to be found in the diplomatic correspondence which, if considered without regard to their context, might be regarded as acknowledgments of the United States' claims to exercise consular jurisdiction and other capitulatory rights. On the other hand, the court cannot ignore the general tenor of the correspondence, which indicates that at all times France and the United States were looking for a resolution based upon mutual agreement, and that neither party intended to concede its legal position. In these circumstances, the situation in which the United States continued after 1937 to exercise consular jurisdiction over all criminal and civil cases in which United States nationals were defendants is one that must be regarded as in the nature of a provisional situation acquiesced in by the Moroccan authorities.
All right. So, as we recall from class 48, we learned that the ICJ blamed who for not being there at the ICJ, representing themselves as a party, as a person on behalf of the treaty. They blamed who? The Moroccan authorities. And who are the Moroccan authorities? The Moors. Who's the Moroccan authorities? Moroccan state governments. So therefore the ICJ is pointing out that the Moors acquiesced. What does acquiesce mean? We were passive. What does passive mean? We passed over our sovereignty over to the United States. How did we do that? Because we were stateless. And when you're stateless, you cannot enact any legislation and you cannot enforce treaties. So therefore, the United States, right, through their constitution, they were what? States. And they had ratified, deposited their constitution. They had ratified and deposited what? Listen to me. I got 4 treaties in my hand. Treaty of Peace and Friendship, 1787, 1836, Treaty of Madrid, and the Act Algeciras, 1906. So they had ratified and deposited their constitutions. Then they ratified and deposited all the treaties. They became what? The competent authority, because they had put all this on the record. Okay, now let's look at the Moors. Where's the Moors' constitutions? Ratified and deposited constitutions on the record with the United Nations Charter, Article 102. AMPAC has a constitution, yes, but we're talking about Moors right now who are what? Stateless. So have the Moors ratified and deposited their constitutions in each of the territories? Have the Moors taken the treaties and ratified and deposited them with the United Nations Charter, Article 102, and through their JUSTIC? Have we done that? And that's the reason why the ICJ says what? That the Moors had acquiesced because we failed to follow the instructions of our own treaties. Okay? That's what we got to understand as we continue. Okay, Mo.
Accordingly, it is necessary to conclude that apart from the special rights under Articles 20 and 21 of the Treaty of 1836 and those which arise from the provisions of the Act of Algeciras, to which reference has been made above, the United States claim to exercise and enjoy as a right consular jurisdiction and other capitulatory rights in the French zone came to an end with the termination of all rights and privileges of a capitulatory character in which the French zone of the Sharifian Empire by Great Britain in pursuance of the provisions of the Convention of 1937.
Okay, so listen to what's happening. The ICJ is pointing out something for the Moors. The ICJ is pointing out that the United States of America lost their jurisdiction in Morocco of capitulations and extraterritorial jurisdiction. Why? Because Great Britain, along with the other signatory powers, remember when we read this document, there was a certain subsection that said that there was 12 signatory powers. And by the time they went to court in 1950, that's when this started, then the judgment came out in 1952, all the signatory powers had relinquished their jurisdiction in Morocco, and the only one left was the United States of America. But never forget that France was still a part of this because France was acting like a power of attorney, a vice sultan on behalf of Morocco. So therefore, France was looking at it like, well, we're not one of the Christian powers. We're the power of attorney for the sultan, right? They wasn't counting themselves as a Christian power. But the ICJ came and said, nah, you are a Christian power, all right? So in this article, it's already stated the United States of America lost their jurisdiction. But how did the ICJ enforce it? Well, it's looking at the treaties. It says, accordingly, it is necessary to conclude that apart from the special rights under Articles 20 and 21 of the Treaty of 1836 and those which arise from the provisions of the Act of Algeciras, to which reference has been made above, the United States claim to exercise and enjoy as a right consular jurisdiction and other capitulatory rights in the French zone came to an end with the termination of all rights and privileges of capitulatory character in the French zone of the Sharifian Empire. Keeping in mind, Sharifian Empire is the Moorish Empire. Keep in mind that there's a lot of dynasties within the Moroccan Empire, okay? You have the Sharifian Empire, you have the Mohammedan Empire, and it's always been the Moorish Empire with a bunch of overlay names on top of that, okay? So the Sharifian Empire is the Moorish Empire by Great Britain in pursuance of the provisions of the Convention of 1937. So once Great Britain said they were out, the United States of America was the last Christian power. According to the treaties, they were claiming any jurisdiction. So since the other Christian powers were out, the ICJ said, well, you can't have any more privileges the same way the other Christian powers had because there's no more Christian powers. It's really only you, United States of America. So now you have to abide now simply to the treaty. The treaty is giving you a limited jurisdiction. The treaty is giving you limited jurisdiction. I'll say it again. How is the United States is holding on to jurisdiction in Morocco? Our own Moroccan treaties is giving them the authority to hold on to jurisdiction in Morocco over Moroccan subjects. That's the reason why the ICJ is pointing out Articles 20 and 21 of our Moroccan treaties. Now let me ask you a question. Did the ICJ say the United States of America's Constitution is what's giving them jurisdiction? No. The ICJ is pointing out what? That Moroccan treaties, Articles 20 and 21 of the Treaty of 1836, and those which arise from the provisions of the Act of Algeciras, which is another Moroccan treaty. So what's giving them their political jurisdiction to hold on to Moors and Morocco? Our treaties. Why? Because Moors acquiesce and we're not enforcing our own treaties through statehood. Let's continue. All right, so now the ICJ is now about to take a look at a different subject matter. This subject matter, just to give you a quick brief, the United States was saying, well, since we conquered the Moors, we don't have to abide by their Moroccan treaties when they try to enforce their own treaties on us. We conquered them under extraterritorial jurisdiction and under capitulation regime. We don't have to listen to Moors. They acquiesced, right? Wrong. Because why? Treaty is the supreme law of the land, no matter what. Just because a person's in a coma doesn't mean they don't have a right of claim to their estate. Once they come out the coma, they get to now use their pen and get all of their effects returned back to them without any interruption. It must be deposited back to them, but you got to make the proper claim, right? Okay, so let's read what the ICJ was saying about the United States of America making a claim that Moors had to get their permission, okay? And keep in mind, France is also involved with this, so you're going to learn about what France is saying, you're going to learn about what the United States is saying, okay? So pay attention. Okay, Mom.
The court will now consider the claim that United States nationals are not subject, in principle, to the application of Moroccan laws, unless they have first received the assent of the United States government.
Okay, let's stop right there. So what's happening in this first sentence? It's very important. This is a powerful sentence. The court, the ICJ, will now consider the claim. So the United States is claiming, right? Right? They're claiming the United States nationals. So who are the United States nationals? The citizens of the United States. They're claiming they're not subject in principle. What's the principle? Triple principle. Right, of Moroccan law, right? The principles of Moroccan law. They're saying they're not subjected to the triple principle of Moors, to the application of Moroccan law. So they tell you, what is the principle? The application of Moroccan laws. What applications of Moroccan laws? What are the applications? The applications is any legislation that the Moors put together, such as Moorish states, any type of Moorish legislation. Even the Moorish treaty itself. The United States is trying to say they don't have to abide by it because the Moors have been conquered. The Moors are now wards of the state. What does that mean? What does wards of the state mean? That means you're a prisoner of war. That's what capitulations mean. You're a prisoner of war. And you don't have to give prisoners of war any rights, other than treating them with what? Human rights. But that's it. They have no legislative rights. So therefore, the United States of America, it says in principle, they don't have to abide by the applications of Moroccan laws, unless they have first received the permission of the United States government. So the United States government was saying, first, Moors have to get the permission of the United States in order to enforce their Moroccan laws. The audacity of that, right? So the ICJ is now taking a look at this, right? Now, I don't blame the United States. Let's just pause for a second. At this time, in 1950 to 1952, the United States appears to be in the driver's seat, right? They have run the Moors out of government, and they've taken over the world. So you can understand their arrogance, right? But they now wanted to challenge that in the ICJ to see if, in fact, they could get the ICJ to approve that the United States get to maintain what's called perpetual extraterritorial jurisdiction, as well as perpetual regime or capitulations, meaning can they keep the Moors in perpetual prisoners of war, right? All right, so now, here's the ICJ saying, okay, here's what France said about this, okay? The French submission is disregard reads as follows. Okay, now here comes, the ICJ is going to tell you what France was saying. Okay. Mother?
That the government of the United States of America is not entitled to claim that the application of all laws and regulations to its nationals in Morocco requires its express consent, that the nationals of the United States of America in Morocco are subject to the laws and regulations in force in the Sharifian Empire, and in particular the regulation of December 30th, 1948 on imports not involving an allocation of currency without the prior consent of the United States government.
Okay, so France, you gotta remember now. Why did France bring the United States into the court in the first place? They were arguing over this December 30th, 1948 trade agreement that the United States had signed with France. And the United States had agreed through this trade agreement of 1948, the United States agreed to pay taxes on imports, etc., exports, imports. France was collecting the taxes, right? So France is saying the United States is obligated to Moroccan law because France was using Moorish treaties to collect taxes from the United States. So France is saying, yeah, the United States owes us taxes because of the Moroccan treaties. This is France saying. Is France the Moors? No. Is France Morocco? No. But they were enforcing Moroccan treaties on the United States. The United States said, time out, man. Y'all can't do that. So they wanted to challenge it in the ICJ. Okay. So what is France saying? That the government of the United States of America is not entitled to claim that the application of all laws and regulations to its nationals in Morocco. So the United States of America is where? In Morocco. This is France saying, right? Requires express consent. That the nationals of the United States of America in Morocco, you see what France is doing? They just doubled down on it. United States of America is where? In Morocco. Not at Morocco. They're in Morocco. Are subject to the laws and regulations enforced in the Sharifian Empire, and in particular the regulation of December 30th, 1948 on imports not involving all allocations of currency without the prior consent of the United States of America. So France was saying they didn't have to get the United States permission to tax them, even though the United States had already agreed in a contract. But France is saying the treaty said, I really didn't have to get your permission to tax you. I could tax you. But the problem was, France is not the Moors. The treaty is expressive. It says what? That the Moors get to enforce these jurisdictions. We'll go over this in just a moment. All right, let's continue. Mother?
The United States submission in this regard reads as follows. 4. Under the regime of extraterritorial jurisdiction now exercised by the United States in Morocco, United States citizens are not subject in principle to the application of Moroccan laws. Such laws become applicable to the United States citizens only if they are submitted to the prior assent of the United States government, and if this government agrees to make them applicable to its citizens. The Dahir of December 30th, 1948, not having been submitted to the prior assent of the United States government, cannot be made applicable to U.S. citizens.
All right. So what's happening? This is the United States talking now. The United States is talking big, right? They letting France know we're standing on our square. What square were they standing on? The United States is standing on what? Listen, your Moroccan treaties. The United States don't have a treaty that says United States of America's treaty. All their treaties say Morocco. They're using your treaty against France. Listen. The United States submission in this regard is as follows. Under the regime of extraterritorial jurisdiction now exercised by the United States in Morocco. This is United States talking. The United States is admitting they're where? In Morocco. But they're also admitting what? They were exercising extraterritorial jurisdiction, which is what? Capitulations on the war. That the treaties became null and void because Moors got conquered. Okay? Under the regime of extraterritorial jurisdiction now exercised by the United States in Morocco, United States citizens are not subject in principle to the application of Moroccan laws. Such laws became applicable to the United States citizens only if they are submitted to the prior set of the United States government and if this government agrees to make them applicable to its citizens. The Dahir of December 30th, 1948, that was that trade agreement, not having been submitted to the prior set of the United States government, cannot be made applicable to United States citizens. What's happening? So the United States of America signs contracts. But you have to remember, they operate as two separate entities. Right here, they're saying the United States didn't agree. The United States of America agreed, but the United States did not agree. And the United States is the government they're operating underneath. See the games they play? So the United States of America signed a contract, but since the United States did it, the United States saying that they're not obligated. You see? Listen. The claim that Moroccan laws are not binding on the United States nationals unless assented to by the government of the United States is linked with the regime of capitulation. We talk about this word capitulations a lot, right? This is why. And it will not be necessary to repeat the considerations which have already been discussed in dealing with consular jurisdiction. So by the way, that sentence I just read was the ICJ saying that, right? In other words, in the prior decision, they had already said the United States of America could not have jurisdiction over Morocco because all the other Christian powers got out of Morocco. So therefore, the United States of America could not hold on to custom and usage of just being accustomed to and used to having jurisdiction over Moors, right? However, the ICJ said, but since the Moors by default had not enforced statehood, they had to give the United States a limited privilege to hold on to jurisdiction until the Moors came back into statehood. Why did they say that? Because they said it must be a consular jurisdiction, it must be courts at all times according to the treaty. So by default, the United States is holding on, but they're not holding on under what they call an absolute lawful claim. They're holding on because the ICJ gave them a temporary stay that terminates at the time any Moors ratify and deposit a Moorish state government in each of the territories. You got to understand what's happening, all right? So the ICJ now is taking a look at this, okay? Okay, mother, right here.
There is no provision in any of the treaties which have been under consideration in this case conferring upon the United States any such rights.
Any such rights or what? Let's listen to that. That's a powerful sentence. There is no provision in any of the treaties which have been under consideration in this case conferring upon the United States any such right. Any such right of what? That the Moors have to get their permission to exercise their right of Moroccan law. You see what the ICJ just said? Okay, so what should Moors take away from this immediately? We don't have to get the United States permission to enact our states. We don't have to get their permission to enact our judicial orders to them. And we don't have to get permission to create legislation through our states that secure the rights of our Moorish nationals. And we don't have to get permission now that we've enacted laws to tell the United States that they also have to enact legislation that talks about what the obligations are of their citizens. Okay, so listen. The United States of America has a Congress. Don't get me wrong, they are a corporation. They're operating through a constitution, but that constitution is really a charter for municipal corporation matters, right? So Moors have to do what? We have to enact laws for our constitution. Listen, we enact laws through our constitution, and through our state, we also enact laws that tells the United States that they have to enact a legislation such as the rights of indigenous people. We tell them, you shall ratify and deposit the rights of indigenous people, and you shall enact legislation where your citizens are now obligated to that legislation that your consular court told the United States of America they have to enact some laws. Why? How is it that we can do that? Because the United States of America is where?
In Morocco.
They're in Morocco. The United States is where? In Morocco. So the Moroccans can tell the United States of America what they shall and shall not do. This must be understood. So right here, there is no provision in any of the treaties which have been under consideration in this case conferring upon the United States any such right. Any such right to do what? Tell Moors they can't enact law, and to tell Moors that the United States is not obligated to that Moroccan law. That's a very powerful sentence that Moors must understand. Moors have been doing what? Listen to me. Moors have been taught to enforce the Constitution of the United States of America. This is not the answer to the test. The answer to the test was what? You were supposed to do what? Enact your own Constitution, and then through the legislation of your government, you tell them what to do. But you don't keep asking these people to enact legislation for you. You tell them through your government what to do. That must be understood. We have wasted a lot of time waiting for colonists to enact legislation for us. That time is up now. We shall enact legislation of our own. Okay, Mom.
The so-called right of assent is merely a corollary of the system of consular jurisdiction. The consular courts applied their own law, and they were not bound in any way by Moroccan law or Moroccan legislation.
Okay, stop right there. Okay. Look how the ICJ talked to the United States of America. Look what they said. The so-called, this is the ICJ. The so-called right of assent. Why do they call it so-called? Because there ain't no such thing as Moors having to get the permission of the United States to do anything in Morocco. The so-called right of assent is merely a corollary of the system of consular jurisdiction. So what's happening? Why did the ICJ say that it was a corollary of consular jurisdiction? Because the ICJ had already in the previous article said that the United States could hold on to a limited jurisdiction. It's only corollary as long as the United States still has the jurisdiction. As soon as Moors come into statehood, the United States no longer has jurisdiction, which means now they must abide to what? The consular jurisdiction of Moors. The consular courts applied their own law, and they were not bound in any way by Moroccan law or Moroccan legislation. Let's pause there for a second. You see how the ICJ just separated two things? They just made distinctions of two things. Listen very carefully. The consular courts applied their own law, and they were not bound in any way by Moroccan law or Moroccan legislation. Now keep in mind that ICJ, just to give you a quick brief, they're pointing out that if two states don't have a treaty amongst themselves, if the treaty does not have provisions as it relates to who has the consular jurisdiction, then back then they have to negotiate who was going to have the supreme law, okay? So just to give you a quick snapshot, then when we go forward, you'll understand what I'm saying, okay? So listen, the consular courts applied their own law, and they were not bound in any way by Moroccan law or Moroccan legislation. See, there's a difference between Moroccan law. What's the Moroccan law? The treaties. But what's the Moroccan legislation? That's your constitution and all the legislation you write through your state. Okay, so there's Moroccan legislation, then there's Moroccan law, the law of their treaties. Then there's their state that writes legislation that now your Moroccan nationals must abide by, and you also write Moroccan legislation that the United States must abide by. We must always give the United States orders to ratify legislation. That way their citizens and their so-called courts and their police understand how to deal with de jure mores of Moroccan states. Because you gotta remember, the treaties are bilateral treaties. They got every right to be in Morocco according to the treaty. So we have to have laws that now say how the citizens of the United States can cohabitate with Moors. We tell them how they deal with us. Okay? All right, let's continue. This all makes sense to you. Okay, Mom.
Before a consular court could give effect to a Moroccan law, it was necessary for the foreign power concerned to provide for its adoption as a law binding on the consul in his judicial capacity. It was the usual practice to do this by embodying it either in the legislation of the foreign state or in ministerial or consular decrees of that state issued in pursuance of delegated powers. The foreign state could have this done, or it could refuse to provide for the enforcement of the law. There was a right to assent only to the extent that the intervention of the consular court was necessary to secure the effective enforcement of a Moroccan law as against the foreign nationals.
Okay, so what the ICJ is explaining here, that there must be a law in place between the two parties that says who has the jurisdiction. And if there is no law already set forth, then those two states that have a dispute, now they must agree who has the jurisdiction. But here's the good news. The United States of America had already agreed to give the Moors the original jurisdiction. That's why they pointed out. Let's go back up. That's why they pointed out right here. See, the ICJ is getting to a point they're getting ready to make. They said right here, they pointed out what? Articles 20 and 21 had already said the United States of America had agreed to the jurisdiction of Moors. And then they pointed out what? So there was the Treaty of 1836 and of those which arise from the provisions of the Act of Al-Jassera. You see what the ICJ did? Yeah. They said, you, United States of America, y'all are agreed that the Moroccans, i.e. the Moors, have the original jurisdiction in dealing with disputes. We're going to go over that in just a second. This next paragraph is one of the most important paragraphs in the entire France versus United States of America judgment. This next paragraph is one of the most important. Now, it's followed by several other paragraphs that get into more details, but you really have to pay attention to what we're about to read, okay? This is what every Moor in northwest of Mexico must understand. Okay? All right, Mom.
In the absence of any treaty provisions dealing with this matter, it has been contended that a right of assent can be based on custom, usage, or practice. It is unnecessary to repeat the reasons which have been given for rejecting custom, usage, and practice as a basis for extended consular jurisdiction, and which are largely applicable to the right of assent. It is, however, necessary to point out that the very large number of instances in which Moroccan laws were referred to the United States authorities can readily be explained as a convenient way of ensuring their incorporation in ministerial decrees binding upon the consular courts. In that way, and in that way only, could these laws be made enforceable as against the United States nationals, so long as the extended consular jurisdiction was being exercised.
Okay, let's go back and comprehend. You have to really understand what the ICJ just said. You have to look at this from the perspective of a Moor. How do Moors comprehend what was just said? What was said in plain English, okay? They just told you the true uncontrollable power of consular court. How do Moors get their rights? Okay, let's read it. In the absence of any treaty provisions dealing with this matter, so that first sentence is important. See, the ICJ said, well, if there was an absence of any provision language in a treaty, then yeah, the United States of America would be correct by saying that Moroccan law would not be applicable to them if it wasn't already set forth in a treaty. So the ICJ is saying, well, in the absence of any treaty provision, right, in dealing with this matter, but we all know that in the treaty, and we'll go over the treaty, that it's already been expressed that the Moors have the absolute jurisdiction, okay? So in the absence of any treaty provisions, what's the first thing we're learning with the treaty provisions? Did it say in the absence of the Constitution of the United States of America? Is it talking about the Constitution of the United States of America? No. It's talking about the treaties, right? Okay. In the absence of any treaty provisions dealing with this matter, it has been contended that a right of assent can be based on custom, usage, or practice. So therefore, if there was an absence of a treaty provisions, then you would go to default and go into custom and usage practice. But since there is a provision that talks about consular jurisdiction, then the ICJ said, well, since there is a provision, what is the provision? Articles 20 and 21 of the Treaty of Peace and Friendship, right? 1836, as well as provisions in the Act Algeciras. We'll go over that in just a moment. It is unnecessary to repeat the reasons which have been given for rejecting custom and usage and practice as a basis for extended consular jurisdiction. So what did ICJ say? You can't use custom and usage because there are treaty provisions, right? And which are largely applicable to the right of assent. So you don't have to, Moors don't have to get the permission of the United States of America because the treaties already gave the permission. The United States of America already signed the treaties giving the Moors the absolute de jure jurisdiction in all matters of civil and criminal jurisdiction. All right? Listen. It is, however, necessary to point out that the very large number of instances in which Moroccan laws were referred to United States authorities, so there's been a lot of people trying to enforce Moroccan treaties on the United States. ICJ is pointing this out, saying this is a reoccurring problem. People trying to enforce Moorish treaties on the United States, and the United States hasn't been abiding by it, right? So listen, it is, however, necessary to point out that the very large number of instances in which Moroccan laws are referred to United States authorities can readily be explained as a convenient way of ensuring their incorporation. They're going to tell you now, how do you ensure that the United States incorporates the binding law on them? They're about to tell you. Ensuring their incorporation in ministerial decrees binding upon the consular courts. So what's the answer to the test? If you want to get the United States authorities, right, to do what? To ensure the incorporation of your laws, what do you need? You need consular court to issue what? Ministerial decrees that makes it binding on who? The United States authorities. Listen. ICJ continues to say what? In that way, and in that way only, could these laws, what laws? What laws? The ministerial decrees of the consular court laws, those laws of the consular court, the laws of the consular court, these laws be made enforceable as against United States nationals, so long as the extended consular jurisdiction was being exercised. What's happening? From the word it down to the word exercise, every Moor should copy paste this from it down to here and put that somewhere you can see it every day. Put it on your bathroom mirror, put it inside your conveyance, put it on your study materials. That way, every time you have slight doubt that you have power, you need to read right here. It is, however, necessary to point out that the very large number of instances in which the Moroccan laws were referred to United States authorities can readily be explained as a convenient way of ensuring, guaranteeing their incorporation. Who's incorporating? the United States authorities have to incorporate, meaning the laws binding on them, and ministerial decrees binding upon the consular courts. So ICJ is saying, who has the obligation to deal with the United States? Consular courts. And when consular court issues its judgments, orders, and opinions, it becomes binding on the United States. But the first obligation was binding on who? Consular courts. So there's obligations on both consular courts and the United States. ICJ is pointing out, you Moors need consular courts in order to make something binding on the United States. Listen. Then they say, in that way, and in that way only, could these laws of consular court be made enforceable as against United States nationals, i.e. their citizens, so long as the extended consular jurisdiction was being exercised. They said the Moors hadn't been exercising what? Their consular courts. Let me ask you a question. Did the ICJ say to enforce the Constitution? Is that what makes your divine right enforceable upon the citizens of the United States of America? No. Did the ICJ say enforce stare decisis of the Supreme Court on the United States of America? No. Did the ICJ say enforce res judicata of the United States on behalf of Moors against the United States? No. Did the ICJ say enforce municipal laws of the municipal corporation, their statutes, up on the United States in order for you to get your rights? No. Okay, if that's the case, you do what? You put this down, and you do what? You enforce consular court to make it your orders binding on the United States authorities. Wait a minute. Let's look at the treaty. Treaty of Peace and Friendship, 1836. This is the ICJ is pointing out, Articles 20 and 21, right? Didn't they go right at that? Right? But you got to catch a key thing that the ICJ said about Article 20 and 21. What did they say in the end? Listen. The beginning and the end. First thing you need is it's about treaty provisions dealing with this matter. That's the first sentence. We're using what? Discernment. We're reading backwards now, okay? We're using discernment. We're comprehending, right? Forensics. What did the ICJ say in this paragraph? Everything Moors have to be based upon what? Treaty provisions. Of what? Dealing with this matter. What matter? How do you get the United States to abide by Moroccan law? That's the first sentence. It's about treaty provisions, not the Constitution of the United States of America. It's about your treaties, Moors. This is what Anna von Ritz was trying to tell you in the letter to Pope. She was saying, go back and look at your 150 years time frame of your Moroccan treaties, because your Moroccan treaties help you enforce the law, not the Constitution of the United States of America. But listen, if the ICJ is pointing out that in the absence of any treaty provisions, so the Moors have been absent. The Moors have been absent of their treaty provisions. Because in your treaty it says what? Okay, let's look at it. We're going to go back to the Treaty of Peace and Friendship, 1836, Article 20 and 21. But first we're going to look at the Acta Algeciras, Article 101. Okay? This is what the ICJ is pointing out. Who has the consular jurisdiction? Who has the consular court jurisdiction over both civil and criminal matters? Keeping in mind, you can't enforce civil and criminal matters unless you have what? A state. That must already be understood. Listen, Mother.
Article 101. The Moorish customs authorities shall directly inform the diplomatic or consular agents of any violations of this regulation which may have been committed by those under their jurisdiction, in order that they may be prosecuted before the competent court. Similar violations by Moorish subjects shall be brought directly to the customs before the Sharifian authority. A delegate of the customs shall be charged to follow the legal proceedings in cases pending before the several jurisdictions.
All right, that's Article 101. So what is the ICJ looking at? They're saying, okay, does the United States of America have the jurisdiction? Or do Moors have the jurisdiction? Okay, common sense tells you, Article 101, Article 101, 101. What's the 101 about? Noble Drew Ali came up with what? The 101s. You want to talk about Chapter 7, Circle 7? Acta Algeciras. You want to talk about 101s? Let's learn about 101s as it relates to Moroccan treaties. Okay, here we go. The Moorish customs, which is the Moorish authority. The Moorish customs authorities shall directly inform the diplomatic or consular agents of any violations of this regulation which may have been committed by those under their jurisdiction. Who's under the jurisdiction? The colonists under the jurisdiction of who? Moors. Listen. In order that they may be prosecuted. Who is the they? The colonists. As well as Moroccan subjects. We're going to learn about that. So they, right? The they, right? The they can be what? Prosecuted before what? The competent court. See that word competent? See, Moors be thinking AMPAC be making stuff up. You have to be the competent authority. What does competent mean? Okay, you go back to what? The Vienna Convention on the Laws of Treaties, 1969, defines what this competent authority means. It means you must be what? Of a state. Because only state can be bound to the treaties. And only the officers of said state can enforce the laws of that state and treaties. So you must be a competent court. So who has the jurisdiction over courts? Moors. Wait a minute. Did it say Moorish Americans? I'm being serious. It just simply says Moorish. No suffix. Let's read it again. Let's talk about the 101s, shall we? The Moorish Customs Authority shall directly inform the diplomatic or consular agents of any violations of this regulation which may have been committed by those under their jurisdiction. So everybody's under the jurisdiction of Moors in order that they may be prosecuted before the competent courts. Listen. Similar violations by Moorish subjects. Similar violation by Moorish subjects shall be brought directly by the customs before the Sharifian authority. So Moroccan subjects are also supposed to come to consular court. Because Moroccan subjects are what? The property the property of the Americans. Moroccan subjects are the property of the Americans. And the Moors have jurisdiction over who? Both the foreigners and their property, which is called the proteges and the Moroccan subjects. So competent Moroccan states and their judicial branch have jurisdiction over the Constitution of the United States of America, over their citizens, and over their Moroccan subjects and proteges. That's what the treaty says, not AMPAC. Listen. Similar violation by Moor subjects shall be brought directly by the customs before the Sharifian authority. That's the treaty. Okay, let's go to Article 102. Mother?
Article 102, every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdiction and on Moor subjects by Sharifian jurisdiction.
Okay. Every confiscation, fine, or penalty must be imposed on foreigners, citizens of the United States of America, by consular jurisdiction. Who has the consular jurisdiction? Moors. And on Moorish subjects by Sharifian jurisdiction. What's the Sharifian jurisdiction? Moorish states. There are three branches of government, one of judicial branch. The consular courts have jurisdiction over who? Moorish subjects, who are naturalized citizens of the United States of America under the 14th Amendment, who are naturalized citizens according to the Treaty of Madrid, Article 15, paragraphs 1 and 2. Article 102. Every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdictions and on Moor subjects by Sharifian jurisdiction. Now listen. Now do you understand why the ICJ, listen, is saying in the absence of any treaty provisions dealing with this matter, what are they saying? If the Moors hadn't come back to the Sharifian authority, the United States of America had a chance to hold on to limited jurisdiction. And if they can hold on to limited jurisdiction, guess what they're enforcing? They're enforcing every confiscation, fine, or penalty must be imposed on foreigners, right? By consular jurisdiction. So they was allowed to hold on to what? A limited consular jurisdiction and do what? Convict Moorish subjects. How do they convict them? Okay, this is how they convict them. Through confiscation. What is confiscation? Confinement. Okay, what else? Fines and penalties. Isn't that what they've been doing to us? They put us in confinement, they sticking fines to us, and penalties. That's what they're doing. They're using our Moroccan treaties against Moorish subjects. Legally. Moors keep saying, United States of America don't have jurisdiction over me. Yes, they do. It's in your treaty. You have now surrendered your right to them to make a claim over you as a Moorish subject. Moors will tell you in a minute they're not a Moroccan subject. Because they think they got what? A nationality card. Tell me the name of the Moorish state government that issued you this card. Moors don't realize that when they say they have a nationality card, you know what they just admitted for the record? That it wasn't issued by a state government. Anybody can have a nationality card. Any national on planet Earth can go and make their own nationality card. But when it comes to what? Competency. Of being a competent authority, the state, the Moorish state issues you state ID. So when you have a nationality card, you don't realize by default, you're saying you're what? A Moorish subject. Because you still what? Subjected to what? The jurisdiction of the United States, because the ICJ told them they could hold on to it until the Moor came back to what? A Moroccan state. Until then, you're still in the jurisdiction of the United States of America. Because you failed to follow the instructions of your treaty. And the ICJ has given the United States of America permission to hold on to you as a Moorish subject. Because in your own identification, you never mentioned anything about this being a state. You got to catch what I'm saying. Moors went and printed this stuff off based upon what they call a private interest law of their divine right. But this right was not issued by a state. Every national on planet Earth gets their identification from their state. You go to Africa, Africa got 54 recognized states, really 55, South Sudan. All of their nationals there have what? State ID. You got 50 states in Europe. All of their nationals have what? State ID. There's 45 states in Asia. All their nationals have what? State ID. There's 35 recognized states in the continent of Mexico. Right? Now it's about to be 36 because AMPAC's on the record with the charter. So AMPAC is on the record with the charter. It's 36 states, recognized states. Because we recognize ourselves, and the charter has a copy of our Constitution, etc., according to Article 102 of the charter. Listen to me. All recognized states of the continent of what's commonly known as America, all their nationals have what? State ID. It is only the Moors of what they call northwest of Mexico walking around talking about they got a nationality card that was not issued by a state. That must be understood, Moors. I'm not trying to throw no Moors underneath the bus, but if we're going to do it right, then we got to do it right. This was a good start. But now you have to take these nationality cards and dispose of them and get an identification from your Moorish state government. Until then, any more that's stateless, meaning you have not consented to a Moroccan state government, is what? A Moorish subject. Moors say, I'm not a subject. Well, okay, what does the treaty say? The treaty say you're a Moorish subject. Listen. This right here is the Treaty of Fez 1912. Treaty of Fez 1912. Article 6 says what? The diplomatic and consular agents of France shall be charged with the representation and protections of Moroccan subjects abroad. Moors are Moroccan subjects, they're stateless. Why has France got to come in and provide protections for Moroccan subjects? It's because you couldn't protect yourself because you didn't have a state. Listen. Treaty of Madrid, 1880, Article 15 says what? You're what? This treaty was about what? Moroccan subjects. This is 1880. Moors say they're not Moroccan subjects. Yes, you are. Why? Because you're stateless. That's the only reason why. But you have the power of the pen to fix it. Through what? Statehood. Okay, so we were going on the Act of Algeciras 1906, right? Articles 101 and 102 that the ICJ gave the United States jurisdiction over who? Moorish subjects. Until Moors come back in the statehood, and then when Moors come back in the statehood, what jurisdiction do they have? Okay, they got jurisdiction over who? They can do what? Every confiscation, fine, or penalty must be imposed on foreigners. And who are the foreigners? The citizens of the United States and the United States of America by the consular jurisdiction. But the consular jurisdiction must be competent of a state. And you can bring your consular jurisdiction towards who? More subjects. Listen to me, it's very important what I'm about to say. The more subjects who've been naturalized can come back to the consular jurisdictions to petition consular jurisdiction because the consular jurisdiction already oversees more subjects. It's in the treaty that the consular jurisdiction already has jurisdiction over more subjects. So when your more subjects, let's for example say they're in prison, they can now petition for the consular courts of each territory to oversee the case regarding those more subjects. Because the treaty already said we have what? Jurisdiction over more subjects already. You have to understand what I just said. But it's on a case-by-case basis. What am I saying? That we don't have to go to the United States and say, United States, we'd like to start representing more subjects that you have in prison. So you don't have to get their permission. Those more subjects in prison can petition each consular court of each state for assistance. So not only can we adjudicate more subjects that are doing something wrong, we can also adjudicate on behalf of more subjects that are now trying to get out of the jurisdiction of the United States. That must be understood. That's what the treaty says. And any more subject, any matter they're dealing with. Okay, let's go back. I'm taking my time on this for a reason. First sentence. In the absence of any treaty provisions dealing with this matter, so any of your treaty provisions dealing with matters, you pick up your treaty to deal with provisional matters of any dispute. Listen, this is your treaty. I'm going to teach you how to enforce your treaty. Article 20. If any of the citizens of the United States or any persons under their protection shall have any dispute. It says some disputes or any. It says any. That's everything. That's entire. Any disputes with each other, the consul shall decide between the parties. Who's the consul? Moroccan states. I just showed you Act of Algeciras. Who's the consular jurisdiction? Moorish. Gets to do what? Decide between the parties. But who are parties? States. In dealing with their nationals or their subjects, Moors have the jurisdiction as parties to decide. And whenever the consul shall require any aid or assistance from our government, who's the government? Moroccan government. Your Moroccan government. To enforce his decision, so what happened? Consular court made a decision. Now, consular court needs assistance in enforcing the decision sometimes. What happened? It shall be immediately granted to him. So the government protects the orders, judgments, and opinions that come from consular court. Your government protects your judicial branch. And your judicial branch protects the government. That must be understood. Article 21. If a citizen of the United States should kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the country shall take place. What country? It's the state now. The states. You place the word country with state. The national state would be Morocco, where Moors finally come together as an alliance. We bring all our states together. Listen. When we start to ratify and deposit constitutions all over the map, at some point we will come together as an alliance and we'll have what's called a central government that oversees all of the Moroccan states. Okay? That'll be what you call the national central government. In the meantime, each of the states will have its own consular court to deal with the affairs of their latitude, longitude of their state. Keep in mind, every corporate state of the United States, each one of their states, let's just say, quote unquote, Texas, as a corporate state, has a Supreme Court, doesn't it? Each one of these corporate states has a Supreme Court. Each one of them. Why? Because all of their constitutions say they have a Supreme Court. Okay, Moors are no different. Okay. Each one of our states will have what? Consular court. You see how it works? But at some point, we'll put together our alliance and we'll come up with a central government that helps to govern the affairs of all of our states. The same way the United States of America governs all its 50 corporate states. They have the Supreme Court, federal Supreme Court, that's also a corporation that oversees the jurisdiction of all their corporate states. All right? Okay. Let's go back to Articles 20 and 21. I'm staying here for a reason. Going back to this is a very important paragraph. That's why I'm staying here for a little while. In the absence of any treaty provisions dealing with this matter, so in the absence of treaty provisions, meaning that if you're absent in enforcing the treaty, then you have done what? You waived your claim because there's an absence of a treaty provisions. So according to the treaty provisions, and dealing with any dispute, you have to do what? Listen. You have to use 20 and 21, right? But wait. We got to go back down to Article 22 again. You can't enforce Article 20 and 21 until you do what? You got to stop being dead first. The Moors are dead. What's dead? Our governments. Our governments have been usurped. Our governments are in a shallow grave because the people are still alive. The Moors are still alive. But they're not sitting in the seats of Moroccan governments. So in the meantime, under treaty provisions, we're dead because we're not enforcing our treaties. So we're absent. We're absent, which means we can't enforce the treaty provisions. Listen, we're going to go over this again. I'm showing you this because Moors cannot enforce Articles 20 and 21 until we come back into statehood. Remember what I told you. The words party and person mean what? State. Article 22. If a Moor shall die in our countries. The Moors died. Why? Because we died with a pen, because the United States of America, through its steep hypothecation and capitulation, said that there was no more Moors. Right? There was a disruption of our bloodline. Right? So if a Moor shall die in our country, so they're claiming the country is not the United States of America. under capitulations in extraterritorial jurisdiction. So the Moors died in the United States because of their pen, their legislation. And no will shall appear. What's the will? No Moors government, no constitutions shall appear. The consul shall take possession of his effects. So who took possession of our effects? United States of America. They said they were the consul. And if there shall be no consul, the effects shall be deposited in the hands of some person worthy of trust. So, who's holding on to our trust? United Nations, right? Charter. Put together a trust. Article 75, right? Which is chapter 12. Then you go over and study chapter 13. It talks about the trust, the council of the trust. The trustees put together a council, right? So this trust, both the United States of America is holding on to the trust physically, which is the land. And the charter is holding on to the trust based upon the fact that they know the Moors get to now come back and make a claim to their trust under an application. See, it's about a pen. How do you get your trust back? A pen. How do you get it back? You enact the Constitution with a pen. And through that same pen, now you enact legislation that tells them they must do what? Deposit the trust back to you through the application of the documentation that you wrote to them and say, we want all of our effects deposited back into the hands of the state, because the state also has a trust. Listen, taking my time. If a Moor shall die in the United States of America and no will shall appear, no constitution shall appear, no government, the consul, United States, shall take possession of the Moor's effects. And if there shall be no consul of the United States, the effects shall be deposited in the hands of some person, state, or organization worthy of trust. So that's the Charter of the United Nations, chapter 12 and chapter 13, as well as the United States of America took over because they had consul, because the ICJ said they had got a chance to be the limited consul. Listen, until the party shall appear. Who's the party? The Moorish state. Parties are states now. Shall appear who has a right to demand them. Demand who? The United States of America to deposit, or shall I say reposit our effects, as well as to the charter members of chapter 12 and 13 of the charter to reposit our effects back to us. But if the heir to the person deceased be present, the property shall be delivered to him without interruption. So who's the him? The state. The Moorish state is the him. So the property, what's the property? Our states, our land, shall be delivered to our state without interruption. Listen. And if a will shall appear, what's the will? The Constitution. Moorish Constitution is the will. Shall appear, the property shall descend agreeably to that will. So in your will, it says what? You have dominions, latitude, longitude. What else does it say? It says you have competent authority, which is your three branches of government, right? What else does it say? That you have a trust. And if the will shall appear, if the Constitution, the Moorish constitutions shall appear, the property shall descend agreeably to that Moorish constitution. As soon as the consul shall declare the validity thereof. So who is the consul? The Moroccan state government and the judicial branch of the consular court. You see this word will? See, the consular court wields the authority, wields W-I-E-L-D, wields the authority of the ministerial decrees, which is called judgments, orders, and opinions from consular court. So the consular court of your state wields the sword. What's the sword? Pen. Consular court, through the state, wields the authority to tell the United States of America and the charter members to do what? To deliver to our state all our effects without interruption. Because the consular court has declared the validity of our Constitution, the validity that we're the competent authority, and the validity that we are Moors, not Moorish Americans, simply Moors. Well, why did I say simply Moors? Wait a minute. Article 21, if a citizen of the United States should kill or wound a Moor, not a Moorish American, it's just a Moor that happens to be Moroccan. And if you're Moroccan of Morocco, that makes you Moorish. Like people from Britain is British. People from Ireland are Irish. People from Morocco are Moorish. But you're not Moorish American. You're just a Moor. Okay. Let's go back here. I'm spending some time on this for a reason. This is one of the most important paragraphs you will read. It is, however, necessary to point out that the very large number of instances in which Moroccan laws were referred to United States authorities can readily be explained as a convenient way of ensuring, guaranteeing that their incorporation in ministerial decrees, remember that's judgments from the court, binding upon the consular courts. So the obligation was on consular courts. The binding obligation was on consular courts to ensure the incorporation of laws to the United States authorities. And then the ICJ tells you emphatically what? They were very specific. They went straight to the heart of the matter. They said what? In that way and in that way only could these laws of consular court be made enforceable as against United States nationals, so long as the extended consular jurisdiction was being exercised. So if it's being exercised, that means Moors are no longer absent. It's just that easy. Now, I'm going to keep reading some more in our next class, class number 50. But as we start to wrap up, we must understand something. What we're reading right here is critical. It's vital. Moors have to take this paragraph, or at least from here to here, and you need to look at that every day. It does not say enforce the Constitution of the United States of America. It does not say enforce the statutes of the United States. It does not say enforce the res judicata of the United States. Why? Because the treaty is supreme law of the land. Everything's about treaties. But watch this. Listen. Moors have been taught to enforce the Constitution. But the Constitution is made up of legislation. And through that legislation, the Congress has enacted in 1871, Act of Congress, February 21st, 1871, what did they do? They created a government called the United States Corporation. And international law, they referred to it as what? An international organization. Listen to me, follow me. And through the United States, they enacted statutes, didn't they? Okay, listen. In the Act of Congress, 1871, they themselves admitted that the United States was for what? Municipal corporation purposes. Didn't they say that? All the Moors know this. But yet the Moors are enforcing the statutes of a municipal corporation. And what did the United States say that their municipal corporation is as it relates to law? Okay, let's learn about that. Black's Law Dictionary, 4th edition. Municipal corporations de facto. This is the United States wrote this. Listen. So municipal corporation, that's the United States. But the Moors have been enforcing the statutes of the United States. We've been retaining and reciting through our mouth and through our written affidavits their statutes. And look what they said about their own statutes. Look what the United States said about their own statutes. The title says everything already. Municipal corporations are what? De facto. What does de facto mean? Means of fact. It's a fact. But is it true? They get ready to tell you the truth. What did I tell you? They confess. Listen. Municipal corporations, de facto, one which exists when there is one, some law under which a corporation with the powers assumed might lawfully have been created. So they created what? Some laws of powers to do what? Enforce a corporation on the people. Number two, a colorable. Colorable. Colorable means what? Deceptive, right? Colorable means what? Counterfeit. Colorable means what? De facto. It's a fact law, but it's not truth in law. Listen, this United States wrote this. It's a colorable and bona fide attempt to perfect an organization under such a law. They're attempting to enforce colorable law. Listen, number three, user of the rights claimed to have been conferred by the law. So Moors are using colorable laws of a de facto corporation. Wait, there's more. Listen. Municipal law. This is what Moors are studying every day. We've been studying their local state statutes, even though they don't even have organic states. They're a corporation by their own admission. Listen. Municipal law, which is what? Statutes of what? A corporation. So their municipal law already told you what? Is what? Colorable. Listen. Not the law of the city only, but that law of the state, right? So municipal laws are for their state. You see how they spell the word state? Lowercase s. They're telling you it's not an organic state. Lowercase s, when they write their statutes, they never write the s capitalized because in international law, they spell the state with a capital S. So Moors must understand when you put the state in lowercase s, that's contrary to international law. Contrary to international law. But wait a minute. Let's just look this up real quick. We're going to get back to this definition. I just want to show you something real quick. Listen. We're going to go to your treaty. This is the Treaty of Madrid, 1880. Okay. You go on down. We'll show you this real quick. You go on down. You go up to Article 7. So you go to Article 7. Okay? Article 7, okay? Article 7, follow me, says what? Right protections in Morocco, July 3rd, 1880. They shall furnish annually to the said minister a list of names of the persons protected by them or by their agents through the states. See the capital S? That's the treaty. Treaty, supreme law of the land. States is with a capital S. That's the reference point. Okay, let's go back. State should have a capital S. Okay, listen. Here's the point. Municipal law is what? It's a contradistinction to international law. Moore's talking about international law, but you're trying to enforce local corporate state statutes that are colorable for a corporation, and everything that the United States of America has is what? A contradistinction to international law. And what is the international law? Listen. The treaties is the international law. Treaties are international law. So if you're trying to enforce municipal statutes, everything you're enforcing is contrary to your Moroccan treaties. But wait, there's more. Listen. It is the law of an individual state, see how I spell state, or nation. They're letting you know it's not an organic state, according to treaties, because treaties say capital S. See, they're already telling you there's a contradistinction to Moroccan treaties, or else they would have put the S capitalized. Okay, continuing. It is the rule of law by which a particular district, community, or nation is governed. Skipping down. That which pertains solely to the citizens and inhabitants of a state, corporate state, and thus distinguished from political law. What's political law? You know what political law is? We learned about that. That's international law of organic states. Remember we kept looking at the word political? That's for organic states. So they tell you off the top that municipal law is what? Is distinguished from political law, which is what? Political law is what? International law. So municipal law is distinguished from what? Commercial law. Municipal law is distinguished from the law of nations. And Moors are out here trying to enforce the Constitution of the United States. Remember what I told you? The front cover says United States of America. But when you open it up, it starts telling you their obligations is to who? The United States. So their constitution is what you call a dualist constitution. Because they're intermixing the word United States of America and the United States all in this constitution. Because this constitution's real obligations is to the United States, but they fool you with the cover page. But when does the real law start for this? In the articles. So when you start reading the articles, that's where the obligation is, not on the front cover. But they fool their citizens, because if citizens see the front cover, they say, oh, this is the Constitution of the United States of America. No, it isn't. It's the Constitution of the United States. Take the time to read it. You will see it. All their obligations is to the United States. I showed you videos of their presidents taking their oath and allegiance to who? The Constitution of the United States. AMPAC don't make this stuff up. So you're enforcing statutes, huh? Okay. What do they say about their statutes? Well, their statutes are listed under what? Note or memorandum. Is what? Under statute of frauds. Their notes, holder in due course, is a note. Their Federal Reserve note, which is their so-called money, is a note. And all their memorandum, what's a memorandum? Notes, right? Applications. All their applications of legislation, they tell you right here, under statute, so statutes are what? Fraud. Well, wait a minute. They already told you that. When you looked up municipal law, they said everything they were doing is contrary to international law. Wait a minute, they also told you that under de facto. They told you off the top, everything they're doing with their municipal corporation is de facto. It's a fact, but not true. Truth in what? International law. Everything they're doing is a contradistinction to international law. But Moors are out here enforcing this, and the United States said all their statutes is colorable. Okay, let's get back to what the ICJ said. What did the ICJ tell Moors to do? Use what? Your treaty provisions. Not the Constitution of the United States of America. Not their stare decisis, because their stare decisis is what? Fraud. Their stare decisis is what? Colorable. Their stare decisis came from what? A municipal corporation. And all their statutes are fraud. So the ICJ is not telling you to enforce the Constitution of the United States or the Constitution of the United States of America. They're telling you, Moors, to get back to your treaty provisions. Dealing with matters. And how do you deal with the matters? It's consular court. And in that way only, could these laws be made enforceable as against the United States citizens, so long as the extended consular jurisdiction was being exercised. And Moors have not been exercising the consular jurisdiction against the United States because we've been too busy writing written affidavits as individual Moors instead of writing consular court orders, judgments, opinions, ministerial decrees through our state government. So listen, AMPAC can point out problems, but we must always point out solutions for all the Moors. Listen. How do the native Moors enforce their divine birthrights? That's the question. How do we enforce it? Well, it starts with what? A pen. Everything starts with the abstract, and then it flows through what? A pen. Because the pen is what? Mightier than the sword. This pen is powerful. Okay? All right, listen. What do Moors need to do? First thing we got to do is what? We got to return to Morocco by abstract. What is that? Abstract. What does that mean? First, we got to know what the heck we're supposed to do. We haven't known what to do. The ICJ is telling you what to do. It's consular court through a state, okay? Now you understand what? The abstract is what? You understand what you're supposed to do. Check the box. You say, okay, I need what? I need to return to Morocco and understand it's about statehood. What's the second thing? You need what? Enactment. You need to act. Noble Ali said to be active. You need to enactment of the Moorish constitutions. Okay? So once you do that, you enact the Constitution. You need your three branches of government. That's the trifecta. That's the triple principle. It said Dorothy needed to click her heels 3 times to go home. What's the 3 clicks? Oh, okay. Your triple principle. 1, 2, 3 is your triple principle. That's the story of Dorothy. Understanding how do you return to Morocco is through the triple principle. Sovereignty and independence, statehood. That's what it's all about. Integrity of domains. Economic liberty without any inequality. That's the triple principle. You have your 3 branches of government. Check the box, right? Check the box. What's next? Ratify and deposit. Constitution, treaties, conventions, and the United Nations charter with the UN Secretariat, Article 102. We got to follow the instructions. We got to deposit all our international law on the record with the Secretariat of the Charter, Article 102. That's the instructions. What's the next thing? Now keep in mind, there's a lot more that's involved with this. I'm giving you the brief, right? These are the main things you just have to understand the basics of. Listen. After you do that, right? Check the box. Now you have to do what? Enact consular court orders, opinions, and judgments as binding on the United States of America and the United States. Isn't that what the ICJ just said? Okay. And when you do that, check the box. I know it's messy. And in that way only, can these laws be made enforceable as against the United States citizens. Did AMPAC say that? No. Your treaty said that. Article 101 and 102 of the Act Algeciras. Your treaty says that. Treaty of Peace and Friendship, 1836, Articles 20 and 21. And then the ICJ turned around and narrated your own Moroccan treaty and told you to enforce the treaty provisions through consular court. And that's the only way to do what? To ensure their incorporation as binding on the United States. And in that way only, could these laws be made enforceable as against United States nationals, so long as the extended consular jurisdiction was being exercised. We have to exercise our rights more. We have to stop taking shortcuts. If we are serious about uplifting fallen humanity, then we'll simply follow the instructions. What instructions? The instructions of our own Moroccan treaties. I end with that. Islam.
Islam.